Committee, Senator Trent, Senate Bill 387, whenever you're ready.
Thank you, Mr. Chairman, members of the committee. For the record, Curtis Trent, representing Senate District 20. The bill before the committee today is Senate Bill 387, which is legislation designed to allow some individuals in a justice-involved circumstance, jail, prison, for lack of a better term, to receive outpatient or jail-based restoration services to reduce the number of individuals who are waiting for inpatient beds for mental health treatment. There are currently about 200 people who have been found incompetent to proceed in circuit court, and they are awaiting an inpatient admission, which is the only thing that DMH can provide right now before they can proceed with their legal action that's against them. This would allow them to get services more quickly and hopefully free up space in our detention facilities as well. I also think there's a good chance that this could prevent the state from facing the possibility of litigation down the road, because 4 other states have had litigation on just this same issue, this same kind of problem. And of course, there are also 12 states who are either in the process of creating or have created the same kind of fix that we're proposing here today. I also think it's important to note for the committee that the language that we have here would exclude dangerous felonies as they're defined in 556, Chapter 556. With that, I'd be happy to answer any questions.
Any questions for the bill sponsor? Seeing none. Witnesses in support.
Thank you. Good afternoon, Chairman Luchtemeier and members of the committee. My name is Nora Bach, and I'm the Director of the Division of Behavioral Health at the Department of Mental Health. And today I'm going to expand a little bit on what the Senator described to you about our proposal for jail-based and outpatient competency restoration. And just briefly, I want to share 3 things with you about that. First, to share a bit more about what competency restoration is, the reason why it may need to be conducted outside of an inpatient facility, and what the benefits are of jail-based and outpatient competency restoration. And you can tell I'm at the point of, I don't know if I need readers or not, so bear with me here. So first, competency restoration may be warranted if an individual with a mental illness or an intellectual or developmental disability or another cognitive impairment commits a crime and is arrested. And if such an individual does not understand why they were arrested or lacks the capacity to understand or participate in court proceedings and lacks that understanding because of the cognitive impairment or mental condition, they cannot proceed to trial. That right is put forth in the state statute 552.020. Thus, in order for the judicial process to proceed, efforts are made to restore that individual's competency in order to assure that they get a fair trial, they have the right to self-defense and to challenge evidence, and basically the integrity of the legal process itself. If there is a question of competency, a judge orders that an evaluation be conducted by a DMH forensic examiner, and if that examiner determines that the individual is not competent to proceed in the legal process at that point, then a judge will order the individual be admitted to a DMH psychiatric hospital. As you're well aware, there is a waiting list associated with competency restoration. Individuals must wait to be evaluated, and if opined to be incompetent to proceed, there is a wait for them to be admitted for treatment. Right now, there are approximately 256 individuals awaiting the initial evaluation, and usually we can work through most of those within the allotted time of 60 days, although sometimes extensions are sought and received from the court. Because of this, we are trying to hire more evaluators. It's estimated that about half of those, so about 128, will be deemed incompetent to stand trial. These individuals will be added to the current waiting list of 237 individuals who have already been evaluated, who are currently awaiting admission to one of our facilities. While they are waiting, they are in a stressful, non-therapeutic environment without medications, and typically their symptoms worsen. They often become very ill and prove to be very challenging for jail personnel to manage beyond the daily issues presented by just a general jail population. Individuals must wait because DMH does not have the capacity to treat all those who wait. Not only do we not have as many beds as would be needed, we are currently not even using all of the beds in our system because of the workforce shortage. These are the reasons why we seek to make competency restoration services available in the jail or in the community for those released on bond. This could mean that some individuals wouldn't have to be admitted to the hospital at all. So Senate Bill 387 would revise the statutes to allow competency restoration to occur outside of the hospital setting. However, inpatient treatment will continue to be an option if individuals cannot be fully restored outside. There are two related budget requests I'd like to make you aware of that support this jail-based competency restoration item. The first budget item would fund an expansion of the forensic mobile teams that are currently based out of the inpatient facilities. And this team of individuals, which includes an advanced practice psychiatric nurse practitioner, a social worker, and a community support nurse, can meet individuals directly in the jails and start them on medication and initiate the restoration services. And these teams will provide services statewide. A second budget item would make funding available to 4 jails. Currently, those are Greene County, Jackson County, St. Louis County, and St. Louis City, to support 10 beds at each location. As with all those that wait, priority is given based on how sick the individuals are. Those with the highest symptom severity are still prioritized for an inpatient bed, but may be started on meds while waiting. Those individuals who present a greater security or flight risk, but who do not need intensive inpatient restoration services, are good candidates for this jail-based program. The funding would pay for the beds, staffing, and for contracted behavioral health providers to come into the jail and deliver the competency restoration services beyond those initiated by the mobile team. For individuals released on bond, competency restoration services can be started immediately in the community by the local CCBHO, that's the Certified Community Behavioral Health Organization, and this can be in any county where an individual might be released. So to pull it all together, individuals must be cognitively able to participate in their criminal defense proceedings. If they are not, they are ordered to receive competency restoration services in a DMH inpatient facility. Since DMH lacks an adequate number of staffed beds, there are long waits for admission. This Senate bill would allow competency restoration services to be delivered in jails or community settings. Both present opportunities for earlier symptom relief and faster stabilization, allowing these individuals to more quickly face their charges and participate in legal proceedings. This will also alleviate some of the considerable strain on jail personnel who struggle to manage with psychiatrically ill individuals who are in their custody, as treatment services can't be started immediately. This legislation is not a panacea, but it does represent 2 viable and clinically appropriate strategies to help us reduce our hospital waiting list. I'm happy to take any questions.
Thank you for that testimony. Any questions for the witness? Seeing none? Thank you.
Thank you.
Further witnesses in support? Oh, and I would ask all the witnesses just to remember, if you haven't already, to fill out a witness form, please. Thank you.
Absolutely. All right. Senators, my name is Megan Travis Henderson on behalf of the Missouri Hospital Association. I'm here to support Senate Bill 387, specifically the inclusion of Section 632-305 in the substitute. So a quick Refreshers 632-305 relates to 96-hour holds or involuntary civil detentions. Last year, the legislature passed and the governor signed Senate Bill 775, which included removed a notarization requirement from the affidavit required to initiate a 96-hour hold. Since that passage, there has been some confusion with some judges as to whether or not that applies to every document in the application packet. And so this legislation is clarification of the intent of the legislature that all of the documents in the application packet are not to be notarized. And I'd happily take any questions.
It's amazing that we had to clarify that, but there we go. Any questions for this witness? And I should also thank Senator Trent for including this within the substitute and the sponsor of that bill as a standalone bill this year. So thank you for doing that. Seeing no questions, further witnesses in support. Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only?
Like I'm a regular here. Mary Fox, Director of Missouri State Public Defender. I tried to decide which to testify in favor or not in opposition or as information. I just want to do informational purposes. I am in favor completely of amending this statute so that people who are in the community do not have to be taken into custody and hospitalized to get competency restoration. We've seen people who are intellectually disabled or who've had a stroke who are living with family members doing well on bond, actually put into jail so they can have competency restoration. So this is a really good fix to that problem. Wait lists, I am unfortunately very familiar with, and these wait lists have once again caused a problem for our clients. As it was reported, there's almost 500 people who are waiting for these services, between waiting for an evaluation or waiting for a bed, and many of those are public defender clients. My only concern is the jail part of the competency restoration. We had a great meeting with Dr. Simmons. She's got some good ideas of things to be put into place, but I'm afraid the statute doesn't create any parameters. So I think we're going to talk again and see if there are some parameters that we can come up with so that it's not just any jail can give somebody psychiatric medications and say, we're doing restoration so that they can go to trial. The Department of Mental Health has control over that restoration procedure and sets up requirements as to what the jails can do. The 4 jails that they mentioned, Greene County, St. Louis City, St. Louis County, and Jackson County, are obviously the 4 largest jails and where many of our clients are and many of our incompetent clients are. So I think that's a great start to start there. But this is a quick fix for today's problem, but I think in terms of long-term, being able to provide this restoration in the community will help as much as being able to provide it in the hospital. And hopefully we don't have to do it in the jail because there will be enough beds. But when staff shortages end, we will all be in a different place, hopefully.
Thank you for your testimony. So I'm just reading back through the bill again. So if it's a dangerous felony, or if it's a dangerous felony, they would be precluded from community treatment. So it would have to be in the jail, which makes sense, and chances are they're going to be in jail.
I think the dangerous felonies have to be in DMH.
So
am I reading that correctly?
The way I'm reading Subdivision 7 is that if you're charged with a dangerous felony, community treatment is available. I'm sorry. If you're not, if you're charged with a non-dangerous felony, community treatment's available. And then sort of by implication, if you're charged with a dangerous felony, that moves you up to Subdivision 6.
Right.
But I think your point is that people who commit non-dangerous felonies also could be moved up to Subdivision 6 and be tried, have their treatment in a jail.
Correct.
And
correct.
so what I'm assuming what you'd be looking for would be something that would clarify that if it's a non-dangerous felony, that it would be just community treatment.
Correct, that they can remain in the community. But also, even if it's a dangerous felony, if it's a person who is very ill, and most of these folks are psychotic, so they're very ill, that jail setting is not a good setting for them to become not psychotic. If DMH can determine which ones are okay in the jail, and there's some parameters there, that's fine. But if it's just the jail deciding, I think we've got some problems. So I just think we need to make certain that as we move forward with this, that we don't, I don't want to go down that slippery slope of taking people out of Fulton State Hospital and the other hospitals and doing them all in the jail. Because I think what we're going to see is folks are not going to get better. And the long-term goal of 552 is to get people healthy enough so they can go to trial and the case can be resolved.
Okay. That makes sense. I'm seeing some nods from the bill sponsor, too, so hopefully he can work on a committee substitute, another committee substitute.
We've been talking with Department of Mental Health, so I mean, this is a cooperative discussion about how to fix this.
Okay,
Yeah.
perfect. Any further questions for Director Fox? Seeing none, thank you for your testimony.
Thank you.
Further witnesses for informational purposes on Senate Bill 387. Seeing none, any concluding remarks, Senator Trent?
No, I just appreciate the committee's time and consideration.
That will conclude the hearing on Senate Bill 387. I am going to call roll really quick since we do have a quorum present.
Senators Lukemeyer,
Here.
Schroer, Coleman, May, Roberts, Thompson Rader, Trent. You have a quorum.
We do have a quorum. Next up is Senate Bill 384. Senator Gannon, whenever you are ready.
Good afternoon, Chairman, members of the committee. I'm Senator Gannon, representing the 3rd Senatorial District. Thank you for the opportunity to present Senate Bill 384, which deals with the Interstate Compact Act for Adult Offender Supervision. The Interstate Compact for Adult Offender Supervision provides states the authority and process for individuals under community supervision to transfer such supervision from one state to another. This legislation seeks to do 3 things pertaining to the Interstate Compact practice: remove obsolete language from statute, impose a transfer application fee, and clarify judicial authority. Currently, statute recognizes 2 separate interstate compacts. This legislation would delete the one that is currently obsolete. Senate Bill 384 would also seek to impose a fee on the transfer application for individuals leaving Missouri. The fund would be used to support the administration of the compact staff development and training, assessment, and implementation of evidence-based practices for the benefit of offenders under supervision. Lastly, at present, offenders who transfer their out-of-state supervision to Missouri are bound to formal conditions issued by the other state. Missouri probation and parole officers may issue additional directives when needed, but accountability measures are limited compared to the options available under formal conditions. This legislation would grant Missouri judges legal authority to impose conditions on interstate probationers residing within the jurisdiction of their circuit. Thank you again, Mr. Chairman, and I believe we have some witnesses that can handle some questions also.
Any questions for Senator Gannon? Seeing none, first witness in support.
Mr. Chair, members of the committee, Adam Allback, Legislative Liaison for the Department of Corrections. The department would like to go on record in support of this legislation. Would also like to thank Senator Gannon for sponsoring this legislation on our behalf. And with that, I'm happy to take any questions.
Any questions for Adam? Seeing none, thank you for your testimony. Further witnesses in support, Senate Bill 384. Any further witnesses in support? Seeing none, any witnesses in opposition to Senate Bill 384? Seeing none, any witnesses for informational purposes only? Seeing none, Senator Gannon, any concluding remarks?
Well, thank you, Mr. Chairman and committee members, for allowing me to present the bill.
Thank you. This will conclude the hearing on Senate Bill 384. Next up, Senate Bill 405, Senator Schroer.
Thank you, Mr. Chair, members of the committee. For the record, Nick Schroer, State Senate District 2, presenting Senate Bill 405. This simply adds the gun laws, Section 5 or Chapter 571, into the endangering the welfare of a child, and changes one word from there to its analogs for the drug manufacturing or distribution. So with that, I will take any questions.
Great. Any questions for the Vice Chairman? Seeing none. Any witnesses in support? Witnesses in support of Senate Bill 405. Seeing none. Any witnesses in opposition? Seeing none. Any witnesses for informational purposes only? That will conclude the hearing on Senate Bill 405. We are waiting on Senator Washington to present Senate Bill 423, and we'll give her a few minutes to get here since our executive session involves rolling her bill into the Vice Chairman's bill. Next up is Senate Bill 423, Senator Washington.
Hi. Thank you for hearing Senate Bill 423 today. This bill almost mirrors, well, first, everyone should have a Senate sub. That is a combination of elements from Senate Bill 406, filed by Senator Schroer, and Senate Bill 423 by me. So I hope you have that. Basically, what this bill will do is move us further towards juvenile justice reform. Some of this is positive, some of it is not. Currently, there are mandatory certification hearings for the 7 deadly sins that we call in Missouri: first-degree murder, second-degree murder, first-degree assault, forcible rape, rape in the first degree, forcible sodomy, sodomy first, and first-degree robbery. Right now, there's the option for any felony filed in the juvenile system to request a certification hearing to certify a juvenile as an adult as young as 12. As someone who went through a certification hearing, that one was illegal because the 7 deadly sins were not part of the mandatory hearings in 1981. And also, you needed to be 13 and a half. I was not 13 and a half. I was 13 and 5 months. I'm very open about what happened. I still went through that hearing, and the stress and pressure of going through that. It is a trial, much like someone who's found guilty of first-degree murder has to go to a second trial for punishment. And it has a negative effect on those who go through that, whether or not they are actually certified. So the pressure of that and the social stigma is horrible. Furthermore, there are way too many studies. There are countless studies out here that 12-year-olds just don't possess the mens rea or mental capacity to commit many of these crimes, most crimes, and so that they should not be forced to go to the adult system, as the adult system is more about punishment, and the juvenile system is really about rehabilitation, and those who go through that system have a lower recidivism rate than the same age child that goes through the adult system. So Senator Schroer and I have worked on this since we were House members, since I walked in the building 6 years ago, to try to raise the age that we actually have the option of sitting a kid, in front of a judge for a certification hearing. Right now it is 12. This bill asks that it goes to 14. I'll be honest, if you loved me, I would really like it to be 16, but I know that we have to work to what's best for Missouri and a compromise. It does add a mandatory hearing for dangerous felonies and manufacturing controlled substance. And the other thing it adds that I think is quite necessary is it adds a requirement of the court's administrator to tell us specifically how many hearings are requested, not how many children are certified. We want to know the petitions filed and the dispositions of those petitions. So we have that information there. And then there's some cleanup stuff because we have moved things to 18. There's some things we had to clean up here to make the language 18 as opposed to 19. And with that, I'll take any questions.
Any questions for Senator Washington? Seeing none. Any witnesses in support?
I'm going to step away. I spilled coffee on myself.
Good afternoon again. Mary Fox, Director of Public Defender. We were here to testify in favor of Senator Schroer's bill, and I think at that time the committee had asked that we bring some statistics in terms of children who were certified, and I did bring those, and I'll submit it with my witness information. I think it's interesting that the law changed in 1995, changing the age of certification from 14 down to 12. I was able to find statistics back to 2002. And the last time a 12 or 13-year-old was certified was in 2006. There were 13-year-olds certified in 2005 and 2006, and one 12-year-old certified in 2004. Other than that, it has all been children who were 14 or older. In addition, though, in 2002, there were 146 referrals where children were certified in the state of Missouri. So in 2021, there were 35. So I think we've changed how we look at certification. We've taken adolescent brain development into consideration. The court does a much better job in terms of seeing, was this a childish act, a result of adolescent brain development where the child was under the influence of peer pressure or just not good thinking that children often do. That's really important, I think, that we get the age back to 14. So I'm going to leave those statistics with you, and I'm hopefully going to find them from 1995 to 2001 too, but they're not as easily accessible.
So I'm sorry. So the aggregate number during those time frames for 12 to 13 certification. 9 kids, and that was over what period of time? You said
2002 to 2022.
Okay, so 20 years. Okay, that's yeah. And then, and you may not have this for those 9 kids between ages of 12 and 13 for that 20-year period. Do we know what types of offenses they were certified for?
No, haven't met
Okay.
It just shows us the number of children who were certified, race and gender, but it doesn't go into the details as to what the charge is.
Okay.
Or whether they were mandatory certification or certifications that they occurred through request or support of the juvenile officer.
Yeah, I mean that's a really small number over a 20-year period. But my assumption would be is that given the small number and how rare it is, they would probably be pretty serious offenses.
Not necessarily.
Okay.
What we've seen in some of the out-state jurisdictions is that kids are frequent flyers.
Yeah.
And the juvenile court just kind of
Wants to get their attention. Yeah.
They certify them to adult court.
Okay. Makes sense.
I don't know if you realize this, but there are actually some children who are saying, certify me to adult court. I'm 13 years old. They're just going to give me probation. So if I'm here, I'll go to division of youth services until I'm 16 or 17. So
Hopefully, that's not the judge's reasoning. I know. I'm just saying. I'm just saying. I'm hoping that logic's not persuasive.
So I'm assuming that the probable cause part of the bill is still in the bill, probable cause hearing as part of the certification process. And that is, I think, a really important part that we have left out of the Missouri certification law. But it's not in here?
No, it's out. It's out. Yeah.
And here's why we need to put it back in. There are kids who sit in adult jail for 3 and 4 years for somebody to decide it's a justifiable homicide or it's a mistaken identification. And can you imagine sitting in jail from 14 to 17 and then being sent back home? We're not asking for like an entire trial prior to certification, but if you look at the United States standards, the Supreme Court standards under the
Yeah, I think we'd heard testimony last time that sort of inherent in the certification hearing would be that there would be a finding of probable cause.
No. There's a detention hearing, which is like, we're going to hold you in detention or we're going to let you go home. There's a very minimal part of determination there. But actually, the law in Missouri says the judge does not have to consider any of the facts of the crime as part of the certification hearing. So it's really, and I've said in court, I've handled certifications where the judge has said, no evidence of a crime is coming in, I'm not going to let you get into that. Even when the evidence is something like, this kid was at school on the day this crime occurred.
Oh, Director, I think your microphone may not be on.
This time, for those of you who are out there, what I said was really good.
All right. Any further questions for Director Fox? Seeing none, thank you for your testimony.
Okay, put that part back in.
Further, no
Please.
guarantees there. Further witnesses in support.
Mr. Chairman, members of the committee, Michael Grote, I'm a registered lobbyist appearing on behalf of Missouri Juvenile Justice Association. We are essentially all the juvenile officers around the state. We are also in support of this legislation. As I think you heard previously, both Senator Schroer and Senator Washington, when they were in the House, worked on legislation on raise the age. This just essentially further goes into that scenario. I don't have, my numbers were not as good as Mary's, but what we did have is from 2010 till 2021, out of 703 certifications, only one of them was under the age of 14. So to your point, Senator, it's a very, very small number of which we're talking about. And although we don't have the information on most of those ages, the predominantly, they were the 17-year-olds, of which Senator Schroer and Senator Washington's language has already addressed 4 years ago now. So that's where the majority of those certifications were coming from. But again, we would support this legislation, and I think as it is in some parts similar to Senate Bill 406, Senator Washington said taking the age to 16, we'd be okay with going to 15 years, as Senator Schroer's language did. So,
Thank you for your testimony. Any questions for Mr. Grote? Seeing none. Further witnesses in support of Senate Bill 423.
Good afternoon, Mr. Chairman and other members of the committee. For the record, my name is Tommy Holland Sr. I am the Vice President for the NAACP Unit 4008-B in Pulaski County of St. Roberts. I am here in support of the Senate Bill 423. Ms. Fox has went over already some great status and statistics, which I was going to cover, so I won't cover those. But two major important points here. One, children should never be housed in isolation, meaning that when a child is certified as an adult, they're removed from juvenile facilities to an adult facility. And I do believe that we all know that could be very, very dangerous, regardless of the situation or the crime that that juvenile may have been committed. So that's one of the things. The second thing, adult punishment are not appropriate for children. I believe we are a society that believes that a child committing a crime should be held at a different standard than an adult. Not saying that the criminal justice system is different. We go through that same criminal justice system. However, where they are housed, that makes a very, very big difference for a 12, 13, 14, or 15-year-old. I also did a little more research that was somewhat surprising to me, if it's still accurate, and I believe it is. It says overall the youth that are younger than 18, they commit 7% of the rest of the violent crime. Now, to me, that's pretty high, but it goes on to say that the average age of these crimes is between 16 and 18 years old. So it's still higher than that 12, 13, 14, or 15-year-old. And another thing I looked at, and I believe it's still active, and I believe it's still a law. It says the Juvenile Justice Care and Protection Act of 1986, it defines what a juvenile is. It says if you're a boy and you have not reached the age of 16, you are considered still a juvenile. It says if you're a girl and you have not reached the age of 18, you are still a juvenile. So I would ask that we look at that and take those into consideration. Mr. Chairman and other members of the committee, I thank you very much.
Great, thank you for your testimony. Any questions for the witness? Seeing none. Remember witness form. Further witnesses in support of Senate Bill 423.
I'm not going to be here long. Brian Birdskater, Missouri Association of Criminal Defense Lawyers. To restate the previous witnesses, we support.
Great. Any questions for Brian? Seeing none. Thank you. Thank you for your testimony. Further witnesses in support of Senate Bill 423.
Thank you, Mr. Chairman, members of the committee. My name is Jeremy LaFavor here today on behalf of Empower Missouri. We don't want to restate things that have been stated here before, but we certainly think that the juvenile justice system is a better place to give these kids a second chance, and they deserve that opportunity to show us what they're really capable of.
Good. Any questions for Jeremy? Seeing none, thank you for your testimony. Further witnesses in support? Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on Senate Bill 423. Would now make a motion that we go into executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those to the contrary say no. The ayes have it. We are in executive session. I would now make a motion to bring before the committee Senate Bill 406. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. All the contrary say no. The ayes have it. Bill is
just allowing for instances where the jurisdiction may not be where the juvenile lives, is where the event occurred, where the crime occurred. We do skip over to page 3, which I have an amendment. I'm going to strike this language on page 3, the last 4 lines, and I'll get to that in a moment. Jumping to the meat of the bill, I guess you want to say, is very similar to what we just heard on 211071, moving the petitions up to 14 and 18 on the certifications outside of the 7 deadly sins, so to speak. We are keeping the certification in those instances for these dangerous felonies between the ages of 12 and 18. And instead of going the route of including armed criminal action, we are including a dangerous felony, which does encompass the armed criminal action on these mandatory certification hearings. Not mandatory certification, but just the hearings that are going to take place. We do have the data collection part that was in my bill to ensure that we are getting all the information needed, so it's not a wild goose chase to figure out who's been certified under what circumstances. And last but not least, on page 10, we do have that programs established pursuant to this section shall include getting an educational degree, getting an award of high school diploma or its equivalent. So when these juveniles do come out, they will at least have that checked off. So they're not going to be docked by going through the process of the juvenile certification and receiving the services that way. They're still going to get the education so they can become productive members of society. So if not any questions, I will offer my amendment as soon as we're done.
I'm going to make a motion that we bring the Senate committee substitute for Senate Bill 406 before the committee. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye.
Aye.
Aye. Those contrary, no. Okay, the committee substitute for 406 is before the committee. Senator Rader.
So if a 14-year-old kills someone, planned and killed someone, is that automatic certification?
That's going to have an automatic certification hearing based upon the certain crimes.
The judge still gets set aside?
Yes, the judge would decide on in any of these scenarios, and I think that's an automatic certification hearing. And I think depending upon those circumstances, if it was a planned murder and it wasn't self-defense, I think in those instances, that child would likely be, a 14-year-old likely be charged as an adult if there's no other extenuating circumstances. But when you look at, I think it's page 5, section 211071, there are certain offenses where the certification process will automatically occur, and that's murder, first-degree assault, rape in the first degree. It goes on, and we're including a dangerous felony as defined in section 556061. So even without this bill, even without the changes that are going to go into this bill, in an instance where a 14-year-old yesterday would commit murder, there'd still be that process where the judge gets to ultimately decide under those circumstances, under the crimes committed, if that person should be better suited in the adult system. So we're not changing that process.
And the raising of the age from 12 to 14 is only for those non-dangerous cases. So if you had a homicide, a 12-year-old, the judge would still have discretion to certify a 12-year-old, which is the case under current law. The judge isn't required to, but would still have the flexibility to do that.
Okay. So like if a 13-year-old planned and killed their stepdad because they were torturing their mom, the judge would still get to make that decision.
Yeah, so today, today the judge would still get the bite at that apple and see if the certification should take place. Certification hearing automatically. Yeah, we're not changing that, and we're ensuring that between the ages of 12 and 18 for these most heinous of offenses, the courts will still have the ability, once those crimes rise up, including the dangerous felonies, if that individual, if that child should be better suited in the adult system. But moving it from 12 to 14, those are the nonviolent offenses. Those are the other offenses. It could be stealing a pack of M&Ms, not murder, not rape, not forcible sodomy, as is defined later in that section.
Okay, got it. Thank you.
Any further discussion on the substitute?
Sheriff, got an amendment.
Senator Schroer.
I have an amendment ending in 01S has been distributed and I move for its adoption.
Second.
So this is just striking on page, I believe it was page 3, those last 4 lines. And ultimately what we're trying to do here is still allow for these kids to receive the services. And we don't want kids to fall through the cracks. We still want the ability for, let's say, St. Charles County, which has happened recently, for them to go forward with the process of taking that kid in. But if they find out that, you know, the kid doesn't have a ride from St. Louis City to St. Charles County, they can transfer it over. So we're just trying to get rid of that section, which could cause some confusion in the transfer process.
Any further discussion on the amendment? Okay, I make a motion that we adopt the amendment. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye.
Aye.
Aye. To those contrary, say no. You guys have it. You have adopted Senate Amendment 1 to Senate Committee Substitute for Senate Bill 406. Any further discussion on the substitute? Seeing none, I would then make a motion that we adopt Senate Committee Substitute for Senate Bill 406 and roll into the bill title Senate Bill 423, which is Senator Washington's bill. Do I have a second? And include the amendment within the sub. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. You have adopted Senate Committee Substitute for Senate Bill 406 and 423. I would now make a motion that we vote do pass Senate Committee Substitute for Senate Bill 406 and Senate Bill 423. It's been moved and seconded. Brad, please call the roll.
Senators Luetkemeyer.
Aye.
Schroer. Coleman. May. Roberts. Thompson Rader. Trent. 5-0.
You're voted 5-0. You have voted do pass Senate Committee Substitute for Senate Bill 406 and 423. No further business coming before the committee. I would now make a motion that we adjourn. Do I have a second? It's been moved and seconded. We are adjourned.
Thank you, Mr. Chair.